Hi, this is Attorney John Teakell. I'm here to speak to you about bankruptcy, fraud, prosecutions in federal court. When a person files for bankruptcy, that is, files their bankruptcy petition, they have to include income, assets, and debt on their petition, and a trustee, a bankruptcy trustee, is assigned by the bankruptcy court to administer the case. That is, they look to make sure that the filings are proper, that the assets are reported, the ability to pay is reported. If a trustee or creditors are concerned about any filing about the financial situation, they can make inquiry into assets or income or anything related to that. If you have a concern about your bankruptcy as it relates to a previous tax return that was filed or a previous loan application was filed or something like that, and you're concerned that information about that might come out, it's possible you could have a bank fraud or a false tax return filing allegation or investigation on top of that. Now, again, the trustee looks for things like fraud, misrepresentation, concealing of assets as it relates to a bankruptcy filing. And the trustee can inquire, as we spoke about a moment ago, but he can also ask for documents and testimony from the bankruptcy petitioner about financial transactions that may look suspicious. Again, the crux of this whole thing for a bankruptcy trustee is to make sure the court is not deceived regarding the ability to pay by a bankruptcy filer and the assets that the bankruptcy filer has to make available for paying debts. Now, if a bankruptcy trustee makes a referral for criminal prosecution to the bankruptcy court and the U.S. attorney, the allegations and charges that a U.S. attorney might pursue would be making false statements in regard to bankruptcy filings, false oaths in regard to a bankruptcy petition, that is an oath that you take that everything is correct and true, a bankruptcy fraud scheme, such as a scheme to have someone hold assets and not report it as assets to the bankruptcy court, and then later return them back to the petitioner after the bankruptcy is finished, some sort of scheme like that. Also, fraudulent transfers of assets and concealing assets. Again, the U.S. attorney would be the person or the prosecuting authority who would pursue charges and actually file and seek an indictment, that is a formal charge in federal court, for any type of fraud, false statement, or concealing asset allegations from a bankruptcy fraud. If you or someone you know is contemplating filing bankruptcy and you have some of these concerns, or if somebody's under investigation that you know for bankruptcy fraud, have them contact me, John Teakell, and I'll guide them through it. Thank you.